5. If I could have counsel get your appearances now.
Brian Ziegler on behalf of Your Honor.
Kyle Travis on behalf of Mr. Menard.
All right, thank you. Mr. Travis, how do you want to proceed in the trial today?
Your Honor, it's my understanding that the prosecutor would resolve the matter on a plea to a disorderly person obscene, which is a 93-day misdemeanor.
Can you tell me that again?
Disorderly person obscene conduct, Your
Okay.
Honor. It's a 90-day and $500 fine.
Is that correct? Plea offer, Mr. Ziegler.
Yes.
Okay. Mr. Menard, have you had a chance to talk to Mr. Travis about this agreement?
I did.
Is that how you wanted to proceed today?
Yes, that'd be fine.
Okay. Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Menard, are you currently on any kind of probation or parole?
No,
All right. And you understand that the maximum possible penalty that you could face for this charge of disorderly would be up to 90 days and or a $500 fine?
yes,
With that in mind, what is your plea to that charge today?
guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify yourself at a trial if you wanted to. You understand all those rights.
Yes,
You understand that you're giving up and waiving those rights by pleading guilty. Has anyone threatened you with anything to get to the plea judgment? Has anyone promised you anything other than what we said here in court today? No. Is it your own free choice to enter this plea?
yes,
Are you entering this plea because you are guilty?
yes,
Mr. Travis, I'm going to ask that you conduct some questioning of your client to establish a factual basis.
Thank you. So Mr. Menard, your house is off a public road, is that correct?
yes,
And your house has a front porch, is that correct?
yes,
And you are in the habit of urinating off your front porch,
yes,
and that would cause your genitalia to be exposed to the public.
yes,
And I think we talked about this earlier, the parties involved in this case, you don't know if they were home or not, but you wouldn't deny that they might have been home at certain times when you were peeing off the porch?
they may have been home.
Okay. Thank you.
Mr. Ziegler?
Well, I guess first of all, Your Honor, your home is located in Calcasieu County, correct?
Yes,
And I didn't hear a date at all testified to, Your Honor.
And this has happened over the past, well, you've been incarcerated for about 2 months, but prior to this year, this has happened a number of times?
yes, I frequently go out in the morning, usually, and urinate off my porch.
Okay.
I do it quite often.
If the allegation is that this happened on or about May 5th of 2025, would you have any reason to doubt that?
Yes,
It could have happened on May
yes,
5th.
Okay. Mr. Ziegler?
Your Honor, it has little or no bearing to the police report, but I would agree it establishes a factual basis for the offense.
Okay. So the court will accept the factual basis to the charge of obscene disorderly. Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis?
Yes, sir.
All right, the court will set this matter for a sentencing hearing. Mr. Menard, you'll be notified of the date and time of that hearing. You'll have an opportunity to speak with Mr. Travis prior to that hearing. Ms. Wagner, I am going to ask, given the circumstances here, even though it's a 90-day misdemeanor, I would like a misdemeanor PSI just with an outline of the factual basis.
Okay, sure thing.
Thank you. And then we'll set this for, again, a sentencing hearing. Mr. Ziegler, anything else that we need to address for the record today?
No, Your Honor.
Mr. Travis?
Yes, Your Honor, if we could address bond.
Okay.
Your Honor, it is by my math, Mr. Menard has about 60, maybe 60 plus days in. His bond was revoked back on 6/10 because he was found at the residence. I read the report on that. Obviously, it was a violation. The situation was there. He had been informed that the parties didn't live there. He had been in the process of evicting them, went back. They actually weren't present, but folks they had left at the house were there. Obviously, he violated bond. He knows that, but he's been in jail for about 2 months because of that. And the reason I just get into the situation is I don't believe it was an intent of Mr. Menard to have any contact with victims. He was acting, which still would have been a bond violation because he wasn't supposed to go to the house, but on information that they weren't present, and they actually weren't present. So we would ask the court to consider reinstating his bond.
Mr. Ziegler?
Your Honor, ordinarily, this would be a misdemeanor plea, and he's served more than 28 days in jail, so I think the pretrial release rule would apply. However, I think in circumstances where the defendant has knowingly and intentionally violated his bond, the pretrial release rule no longer applies. And I would have concerns given how quickly he went back to the residence in this case, despite clear bond conditions that he was not to do so, that he might do so again if he's released. And so I would ask the court to consider continuing his bond or continuing to hold him pending the sentencing, or at least until the 90 days of the plea have expired.
All right. Well, I mean, I'm under first of all, I'm not gonna be able to, we will not have the schedule of the sentencing hearing prior to the expiration of 90 days. So I can't hold Mr. Menard longer than the statutory maximum for the crime that he's pled to. And I don't know that, I don't believe that I have a legal basis to hold him for the maximum and then release him simply because of concerns regarding bond violations. I think that would have to be part of a sentence. So, you know, given that the plea is to a 90-day misdemeanor, given that the court will not be able to sentence Mr. Menard prior to the expiration of the statutory maximum, I think I'm in a position where at this point, the court is going to reinstate bond amount. So he doesn't have to post additional money. The money that he posted, Mr. Menard will continue to be the basis for the money bond. However, all the bond conditions will continue to remain in place. And those bond conditions include, I'm assuming, not appearing at that residence. So Mr. Menard, there's a number of individuals that are listed in the bond here that you're not to be in contact with. In addition to those listed individuals, you're not to have any contact with any minor under the age of 18. And you are not to be at address 10280 Puffer Road. Do you understand that? Okay. So those bond conditions will all continue to remain in place. However, the court will reinstate the bond that was previously issued. So Mr. Menard will be released today, again, subject to those conditions pending sentencing. Mr. Menard, it's important that you stay in touch with your attorney prior to that sentencing hearing. And then Ms. Wagner, how do you want to get in touch with Mr. Menard?
I just sent some paperwork to the jail for him to complete. If he can grab that before he's released and then head over to my office. I'm not here between 12 and 1, but I'll be back this afternoon. So I can give her a phone number, but if he can stop by, that would be better.
Okay, so Mr. Menard, you need to check in with the probation department before you leave the courthouse grounds today, okay? I just need you to acknowledge that for the record.
Yes.
Okay, all right, thank you. Mr. Seeger out in the hallway.
All right, let's talk about the plea hearing for people. Menard had its fair share of eyebrow-raising moments, but Judge Mertz handled it all with his usual steady presence, keeping things grounded, respectful, and moving along the rails. What we saw here wasn't an intense criminal showdown, but rather a candid, slightly awkward, and very real example of how low-level offenses still carry meaningful consequences, especially when behavior becomes persistent. Mr. Menard pled guilty to a 90-day misdemeanor charge of disorderly person, obscene conduct, following a negotiated agreement between the defense and the prosecution. And yes, the factual basis for this one was unique. In plain terms, Mr. Menard admitted that he regularly urinates off the front porch of his home, which is visible from a public road. When asked whether that exposed him to neighbors or passers-by, he responded plainly, yes. There was no attempt to dodge the facts, just a matter-of-fact acknowledgement of behavior that, while possibly routine to him, certainly crosses the line of public decency under the law. Even the judge paused to clarify the date and location before accepting the plea, and prosecutor Mr. Seeger confirmed it satisfied the legal standard. Defense counsel Mr. Travis guided Mr. Menard through the factual questions and later advocated for bond reinstatement. That part of the hearing brought in another layer. Menard had been in jail for roughly 60 days, due to a bond violation returning to the property he was ordered to stay away from. The context. According to Travis, Menard had been attempting to evict the individuals from the house and believed they were no longer present. Still a violation, but not, in their view, a deliberate attempt to contact the protected parties. The prosecutor had a different take. Mr. Seeger expressed concern about Menard's quick return to the property despite knowing the bond terms and opposed reinstating release, suggesting that his behavior raised red flags about potential non-compliance if let out again. Judge Mertz had to thread the needle here, and he did. He couldn't hold Mr. Menard beyond the 90-day statutory maximum for the charge, especially since the sentencing hearing couldn't be scheduled before that deadline. So he reinstated Menard's previous money bond without requiring a new payment, but re-emphasized that all conditions remain in effect. The court was clear: no contact with minors, no visits to the Puffer Road address, and no interaction with those protected under the order. Menard agreed, and before release, was directed to stop by probation to complete a presentence interview. From a legal perspective, it was a clean, procedural hearing. From a human perspective, it offered a rare look at how even minor offenses, when repeated, can snowball into bigger legal consequences. Mr. Menard didn't come off as malicious, just out of sync with expectations. The court didn't shame him, but it didn't excuse him either. There's dignity in that balance. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.